Well, Justin Baldoni just revealed Blake Lively tried to cheat. Gwyneth Paltrow is teaming up with Meghan Markle, and Garcelle stormed off the set of The Real Housewives of Beverly Hills reunion and has quit the show altogether. Lots to get into. Let's dive in. You're listening to No Filter with Zack Peter, your go-to source for all the latest pop culture and reality TV tea, served fresh all week long. Now, let's dive in. And dive in we shall. Welcome on in, everybody. Welcome on in. Welcome on in. Welcome on in. I do have a very special guest that's going to be joining me in just a bit. I have California attorney Daniel Forouzan, who knows all about harassment cases here in California, and he's going to be breaking it down. I got a lot of questions for him, and I'm hoping he'll bring some sense into all of this, because looks like there may have been I have to give a shout out to Without a Crystal Ball on YouTube, who found this loophole that Blake Lively seems to have been using. Here, let me pull this. Well, actually, it's in Baldoni's responses to Blake. So, Blake filed her motion to dismiss, and then Baldoni was like, well, try me. Well, try me. She is trying. And he revealed that, so it's not a, damn it, I thought I had this ready. Give me una momento. But there is a little bit on page 3 of his responses that was caught originally by Without a Crystal Ball. And she found this, and somebody sent it to me, so I just want to give it credit. But so she found in his responses this one little bit. It's bullet point 16, where he was responding to paragraph 16 of Blake Lively's complaint. He says, defendant admits that It Ends With Us movie LLC and Blakel Inc. There it is, Blakel Inc. entered into the document entitled Protections for Return to Production. Attached is Exhibit A to the complaint. Defendant denies that Lively made any formal complaints, that Wayfair failed to investigate or address such complaints. Okay. Why is this so key? Why is this so important? Well, it's important because Blakel Inc. is Blake Lively's company, which means she was an independent contractor on the It Ends With Us film, but she was not an independent contractor, nor was she an employee of Wayfair or of It Ends With Us LLC, which means she was the contractor of Blakel Inc. So a lot of stars, myself included, I also have an LLC. She does not have an LLC. She has an Inc., INC, incorporation, okay? An INC and an LLC, two very different things. However, she's technically working for Blakel Inc., who went into a contract with Wayfair or It Ends With Us LLC. So technically, she's not I hate the name Blakel. I mean, it's not a great name. But so Katie Without a Crystal Ball. Okay, that's her name, Katie. Thank you. So yeah, this we'll see. We'll see what Blakel has to do with all of this, and how this could potentially, debunk or dismiss her case against Baldoni altogether. Like I said, Daniel Forouzan is going to be on in just a bit, so we'll welcome him in just a bit. But first, let's talk about Meghan Markle and Gwyneth Paltrow, because they appear to be teaming up. They're allies. I'll just share the video that Gwyneth Paltrow posted on her Instagram account. She was doing a Q&A, and somebody asked her about her feud with Meghan Markle. They said, are you comprehending the Meghan Markle beef that's on social media? And here's her.
Genuinely do not understand this at all whatsoever. Do you understand this?
So we can see in this clip, we see Gwyneth responding to the question on her Instagram story. She turns the camera over, and who's in the kitchen with her? Meghan Markle, eating pancakes. I don't know. What does that look like? Waffles? Maybe waffles. So could this mean that possibly Meghan Markle and Meghan Markle and Gwyneth Paltrow have been trolling us this entire time? Because we saw that we played the video the other day about her. Let's see. Do I have that video here? I don't think I have. No, I don't think I have that video. I think I may have gotten rid of it. But anyway, we had I keep saying Blake Lively. We had Gwyneth Paltrow, and she was dancing in her kitchen, and she was cooking, and she was barefoot, and she was showing us that she was barefoot. And so people were like, is she trolling Meghan Markle? Because she used the same song that was used in the Meghan Markle promotion of her video. And then Gwyneth Paltrow posted this teaser for the Goop podcast. And then Meghan Markle posted this teaser for her, what is it, Female Founders, Confessions of a Female Founder podcast. And so it was a very similar, kind of the same style of promo where you just see someone's back. In this case, you see Meghan Markle's back of her walking into the studio. And then on the Goop side, you saw the back of, now it is known to be Nikki Glazer, who was making an appearance on the Goop podcast. So I think this was all very strategic. I think Gwyneth Paltrow knows that, there are these comparisons with Meghan Markle, and Gwyneth Paltrow is obviously going to jump in and capitalize off of that and, make herself and Goop a talking point. And obviously Meghan Markle does the same thing. She's also going to make herself a talking point. So I guess there is no feud between Gwyneth Paltrow and Meghan Markle. I wasn't super sold. I just don't think Gwyneth Paltrow cares all that much, but I think someone on her team is obviously very savvy. So I would not be surprised if we see Gwyneth Paltrow appear on not Meghan Markle's podcast, but probably on Meghan Markle's Netflix show. I just can't see Gwyneth Paltrow doing Meghan Markle's podcast. I can see Meghan Markle doing the Goop podcast. I can see Meghan coming on Gwyneth's podcast, but I don't see it the other way around. If anything, Gwyneth may make an appearance in season 2 of With Love Meghan, and maybe that's why they're doing something together. And I'm assuming they're gonna do each other's shows, maybe. I don't know. Someone connected them, but there's no issue. They're good. They all good. Let's talk about Real Housewives of Beverly Hills. Dun, dun, dun. The Real Housewives of Beverly Hills. Beverly Hills. That's where I want to be. Because Garcelle Bouveau has announced that she is leaving the Real Housewives of Beverly Hills, and it's got the internet kind of fired up. Everybody's topsy-turvy, upside down. So Erica Jane and Bose St. John, that's her last name, St. John? They both appeared on Watch What Happens Live last night. Erica was taking lots of shady digs. She poked fun at the sorry, I'm getting a text message. She's poking fun at the Bakersfield Beach House. And sorry, I got distracted. The Bakersfield Beach House, which everybody's laughing about because obviously, that was a joke that I've been putting out there, and it was a good one. It was a funny one. I actually have to give credit to Chef Stu. Stu's the one that originally put Bakersfield in my head, and that's when I ran with the joke. But anyway, so a lot of people are like, Erica's being shady, and obviously people like Garcelle, and she had to leave because the girls are mean girls, and like that's the whole narrative now, right? She storms out of the Beverly Hills reunion because it looks like she was put in the hot seat. I'm told that Bose is the one that puts her in the hot seat. Obviously, she's getting it from some of the other women, but like Garcelle and Sutton have always very much come after the other women very hard, very strongly. So I'm sorry. I don't really feel bad that now the heat has gotten turned on them and they're completely crumbling. We saw it in the finale where Sutton's like her little bird legs are shaking and she's like, oh, and they're about to snap. And I'm just like, girl, you've consistently been on everybody else just asking questions. And that's what Erica said in her confessional. She's like, what? I was just asking questions. And good. Ask all the questions, right? They had no problem kicking all the other ladies in the teeth when they were down. When Kyle was down, when Erica was down, when Dorit was down this season, no problem with it, right? So at this point, I'm like, you know what? Screw it. But so I posted and I was like, what's even crazier is the fact that Garcelle has never really been held accountable, and they want to say that Erica and Rinna and Kyle and Dorit, that they're mean girls, right? Oh, they're so mean to Garcelle and Sutton. They're so mean. When it's just like, how many times has Garcelle, been in the hot seat and she's deflected the conversation by trying to make it a conversation about race, right? She's often tried to twist it and turn it around and turn it into a conversation that it is absolutely not. She's weaponized that a number of times. We saw when Kyle called her out for not making the donation that she pledged, like Amber Heard, she pledged it donation, a big donation, and then didn't make that donation. So Kyle called her out on that, and she's like, oh my God, that's, she tried to imply that Kyle had racial bias towards her because, there's this implication that people from the Black community don't pay their bills. And Kyle's like, that's absolutely not what I meant at all. I just meant you didn't pay your bill. It had nothing to do with, the color of your skin. But that's what Garcelle has consistently done. And that aside, right, the racial weaponizing the racial side of things, she's taken it a step further, and she's literally accused the women of committing crimes. And so that seems to be the crux at the reunion, is it comes up that Dorit may have staged the robbery, or that PK staged the robbery, which to me is such an egregious accusation. Because one, there's no evidence to support that. And I'm glad that Dorit stood up to her. And she's like, who else has said this? You and your 4 other people on Twitter? A read, a serve. Dorit ate with that one, as she should, because Garcelle has constantly tried to make Dorit out to be this, white Karen that's so racist, when Sutton from the South, Sutton Miss I don't see color, that she said on the show, I don't see color. Sutton and Kathy Hilton, come on, have had a number of microaggressions, and it's never been held to that same standard. So I think it's dangerous the way that Garcelle has weaponized that. She accused Dorit and PK of staging the robbery, which I think is dangerous to put on reality television. She accused Erica Jane of being complicit in Tom Girardi's crimes on national television without any evidence to support that allegation either. She trolled Kyle for being a lesbian. And remember, that was a big conversation when Denise Richards was on the show, and they were saying we can't out people on television. And she's consistently done that to Kyle. And then I think the worst one of all was when she accused the women of hiring bots to attack her son online. And then she remember, she went to BravoCon, and she was very much talking about how she did an investigation, even though Diana Jenkins also did an investigation and found out that it was linked to some man that lived in, I believe it was Concord. So he lived up north somewhere. And Garcelle never gave us the findings of that investigation that she did, but she allowed the audience and the public to believe that it was the other women on the show that hired someone to send these bots after her son. So it's really dangerous when you have a platform on reality television and you're accusing people of committing crimes or being complicit in crimes, participating in fraud. You have no evidence to support that, but yet you continue to do that. So what? They threw a book in the trash, and that's the worst that they asked a few burning questions. It's not the same thing as going on national television and accusing people of committing crimes. That to me is a very dangerous game that people are playing. And that to me is, one of the reasons I think we don't it's fine that she's leaving the show. And Sutton never gets held to the same standards. But that's my rant about Garcelle. But anyway, we have a lot to get into. Like I told you guys, I have a very special guest that's going to be coming on the show in just a sec. We're going to be diving into Blake Lively's motion to dismiss against Justin Baldoni, this Civil Code 47.1 that's here in California. We're going to get into the legalities of California law, especially when it comes to harassment in the workplace, in just a sec. But first, I want to give some love to this week's sponsor, and this week's show is brought to you by Nutrafol. This year, there's nothing holding you back from loving your hair again, right? Am I right? Oh, yes, we want that good hair for summer. Becky with the good hair. Hair is so much more than what you see on the surface. It's a reflection of what's happening on the inside. Let Nutrafol target the root causes of your thinning hair and help you grow stronger, healthier strands from within. Nutrafol is the #1 dermatologist-recommended hair growth supplement trusted by over 1.5 million people. See thicker, stronger, faster-growing hair with less shedding in 3 to 6 months with Nutrafol. Thinning hair is different for men and women, so a one-size-fits-all approach to hair growth doesn't cut it. Nutrafol has multiple formulas for men and for women that are tailored to different stages in life, such as postpartum or menopause, or different lifestyle factors, such as, living a plant-based lifestyle. So you get exactly what you need. It's physician formulated with 100% drug-free ingredients, and Nutrafol supports healthy hair growth from within by targeting the root causes of thinning: stress, hormones, aging, nutrition, lifestyle, metabolism. They do this all through a whole body approach. And while other supplements rely solely on ingredient studies, Nutrafol clinically tests final formulations to ensure their efficacy. And you can check it all out at the Nutrafol website. You can build a hair care routine that's super simple and helps feed your hair, like feeding your body, feeding your mind. You want to feed your hair, feed your strands so that they look good. You can purchase online, no prescription required, automated deliveries, and free shipping keep you on track. You can start your hair growth journey with Nutrafol. For a limited time, Nutrafol is offering our listeners $10 off your first month. description, and free shipping when you go to Nutrafol.com and enter the promo code NOFILTER. Find out why over 4,500 healthcare professionals and stylists recommend Nutrafol for healthier hair. Nutrafol.com, spelled Nutrafol, Nutrafol.com, promo code NOFILTER. That's Nutrafol.com, promo code NOFILTER. The link is in the description below. All right. Let's bring on today's special guest. He's been on the show a number of times, most regularly when we were talking about all of the Girardi drama, the Girardi legal saga with Erika Jayne, who we were just talking about a couple minutes ago. Please welcome back Daniel Forouzan.
Hey, Zack, thank you again for having me.
How are you?
I'm not bad, and oh, goodness gracious, the Tom Girardi drama, always in my past, always here. So happy to be here again.
I mean, crazy though, considering we connect, well, the full circle at this point, right? We saw Tom Girardi. You did the final interview with him before he ended up getting all the lawsuits come against him. And then from there, it all played out in the public. It played out in the press. It played out on The Real Housewives of Beverly Hills. And then full circle, just last night, we got Erika Jayne's reaction to her husband getting convicted. Crazy.
Yeah, it is. It's such a wild situation. I never expected for all of this to happen based on a podcast that I filmed October 2021, but here we are.
I mean, your podcast was instrumental. Didn't they use it in the they used it when he was in court here in downtown, right? Because there was something that he said about being a case lawyer and how you have to be very persuasive. I think they used a clip from your podcast about the power of being persuasive.
Yeah, not only did they use the clip, they timestamped, linked to the clip, because in the federal proceedings they use digital documents, so they're used to having actual links in the documents. So they had literal links in the documents. If you want to see Mr. Girardi say X on Mr. Forouzan's podcast, click this link. If you want to see him say Y, click this link. And I was just looking at this, kind of blown away that by the way, I got some heat for keeping that podcast up. People are like, hey, you're going to take this podcast down? It makes plaintiff lawyers look bad. But I don't know. So far, I've left it up.
Yeah. Well, we'll see where it goes from here. Because he has one more. He has the Illinois trial that's coming up, I believe, this month, or did that may have gotten delayed. I haven't heard anything about it. But I mean, at this point, he's already been convicted here in LA, and I think we're now just awaiting his sentencing. Is that right?
I think so. I don't follow it play by play, but
yeah.
As far as me and my community are concerned, that man is discredited and he deserves whatever he gets.
Yeah, I agree. Okay, so let's talk about Blake Lively and Justin Baldoni. This is the case of, I mean, it feels like the case of the century following Depp v. Heard. Everybody's, following this, picking it apart. I mean, Joe Rogan was just discussing it on his podcast. I'm like, Joe Rogan's talking about Blake Lively and Ryan Reynolds. Like, he's not into celebrity, celebrity news, but this case has just gone so far and wide. I mean, internationally, people are following this case here on my podcast. How much of it have you been following lately?
Really, most of what you've been posting, which I always find very interesting. I usually don't get involved in like Hollywood drama, but as I was following your post, I was like, oh, there's a motion to compel. How interesting. I wonder how the privacy right arguments will play out in this motion to compel. I have, however, been researching, 47.1, and I am very well aware of the Fair Employment and Housing Act, which is actually something my office handles. So at least from a substantive or procedural perspective, I know a bit or two about what's going on.
So the latest that we got is that Blake Lively, Ryan Reynolds, her publicist Leslie Sloan, and the New York Times, they're all filing motions to be dismissed from Justin Baldoni's $400 million lawsuit against them. Now, they're all, I don't believe the New York Times is suing him, but Blake Lively is suing Justin Baldoni, Wayfair, It Ends With Us LLC, producer Jamie Heath, Steve Sorowitz of Wayfair, his publicist, Jennifer Abel, and their crisis PR manager, Melissa Nathan. So collectively known as the Wayfair Party. So they have their own litigation against them. But so the latest that we've seen is that Ryan Reynolds and Blake Lively have filed a motion to dismiss. And her case, at least, she's really leaning on this California Civil Code 47.1. Can you explain to us what 47.1 is?
Okay. It's going to take a few steps to really make sense. So give me a moment. Let's just go real big picture, because I was trying to think of the best way to present this. What is a lawsuit? It starts with a complaint that's filed by the plaintiff. You then
Mhm.
move into the discovery phase where they exchange documents, exchange information, exchange oral testimony. At that point, one of the parties can file a motion for summary judgment and go to the judge and say, hey, Your Honor, there's no case here. Please dismiss it. Very high standard, very hard to hit that standard. If the MSJs fail, then it goes to trial. And that's the point at which you get in front of a jury. Okay, well, here's what gets complicated. Let's say in the offset, in the very beginning, the lawsuit's frivolous to begin with. You're going to force someone to go through filing a complaint, defending against that complaint, going through the discovery process, going through the MSJ process, going through the trial process, and then you get a verdict. At the end of the day, if it shows that the complaint was frivolous or bogus, well, the verdict's in your favor, but there's not much more going on other than that. If you want to pursue the person who filed the frivolous claim against you, typically you'd have to bring up a malicious prosecution claim, which is very difficult to do. And guess what? Requires even more money. So in order to defend against certain types of frivolous claims, you're going to be out of pocket 6 figures by the end of this whole thing. And that's granting that the claim was frivolous in the first place. So in California, we have this law called anti-slap. You
Mhm.
may have heard of it. You may have seen it talked about in the Lively situation. And anti-slap applies to this type of stuff. Someone says something and someone else is saying, oh, it's defamatory and going at each other for it. The problem with anti-slap is it only applies to matters that are of public interest. So does a private, whatever you call this, going on between two people, not politicians, but they are celebrities, admittedly, but they're not politicians. They're not determining US policy. But at the end of the day, does this private dispute fall under anti-slap? Well, if it did, the beauty of anti-slap is it comes in the very beginning of the lawsuit. The complaint is filed, and immediately after the complaint is filed, you get the anti-slap. The idea of anti-slap is if you prevail, you don't have to go through the discovery process. You don't have to go through MSJ. You don't have to go through trial. It kind of forces you to prove your case up front, with which, if you're bringing a defamation lawsuit, one would imagine there's defamation, right? So you better
Right.
be able to prove it up front. But this is the issue. Would a private dispute between two employees, actors, contractors, whatever it is that a matter of public interest? And courts have ruled in the past that no, sometimes things like that are not. Really depends on the judge you get. Okay. Now, and I'm sorry for being long winded, but I think it makes the point. We have Civil Code 47.1. Actually, Civil Code 47.1 was drafted by a friend of mine, Vicki Burke. She's a professor at Southwestern Law School in downtown Los Angeles. So I called her before I got on the show so we could have a little powwow. But it's interesting. So far, any questions before I hop into 47.1?
No, I think you summarized that brilliantly.
Good. Okay, thank you. Okay, so let's look at 47.1. It's worth actually reading the language of the statute, which sounds boring, but hold on a second. Let's see. This one has some interesting language. And 47.1 subsection a communication made without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under section 47. So someone sues you for defamation. If you can show that these communications were made without malice and they're related to sexual assault, harassment, or discrimination, you can prevail on a claim of 47.1. Now, this is how it ultimately works. 47.1 shows up at the end of the whole lawsuit chronology that I gave you earlier. So unlike an anti-slap, which comes up in the beginning, but might not apply because they're private parties, 47.1 does apply to private parties. However, it shows up at the very end of the lawsuit. And what it does is this. I'm going to read subsection B. If a prevailing defendant, in other words, the person who's accused of defamation, if a prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to reasonable attorney fees for successfully defending themselves, treble damages for any harm caused by the defamation, in addition to punitive damages. Okay. What 47.1 does is it says if the jury finds that this whole thing was fraudulent, they don't just vote in your favor and it's all over with. No, not only do they vote in your favor, but now there's a fee shifting statute.
Yeah.
The side that filed the fraudulent case has to pay your attorney fees from A to Z. That's got some teeth to it. In addition, they added treble damages. Treble damages say, what damages did the defamation cause you? I lost a contract for $1 million. Okay, treble damages automatically triple your damages. Contract you lost because of the defamation was worth $1 million. Bam, you just got $3 million. This is a lot to chew on. And then the final thing that they throw in there is punitive damages. Now, I was thinking about going into punitive damages, but how familiar are you with them, Zach, before I continue with my monologue here?
I'm pretty familiar with punitive damages. I
me
learned
to
all
go-
of this in the Girardi case.
Okay, good. Do you want me to go into how punitive damages work for your audience?
Yeah, very briefly.
Okay, so punitive damages are an interesting thing. You have the jury trial. If the jury decides that the behavior was done maliciously, you then have a second mini trial for punitive damages. In the punitive damages phase, the idea is to punish the defendant for their malicious, fraudulent, or oppressive behavior. That means you can actually look at the defendant's finances. So McDonald's hot coffee case, very famous version of this. The compensatory damages were only, I think, $20,000, $30,000, $40,000, something in that range. But then McDonald's got hit with like a multi-million-dollar punitive damage. Why? Because in order to get a corporation like McDonald's attention, $50,000 is not going to do it. You need to take millions of dollars. So that's what punitive damages are. They're designed to be punitive.
And
The
so, and
addition of-
punitive damages, those are determined by the jury or by the judge?
by the
The
jury, but then the judge will have, there's appeals that can be done. The judge can rein it in. Sometimes there's a thing where it's like, look, we're only going to give punitive damages up to 10 times whatever the compensatory award was. So let's say you lost your contract for $1 million. And well, what are the punitive damages? They might be capped at 10 million, for example. Some judges say, let's do a 5 times cap. So they might be capped at 5 million. But punitive damages, when you see those big numbers, a lot of the times there's punitive damages involved. So just to finish the point, the reason these 3 things were added to 47.1 is it gives 47.1 aggressive teeth, such that if you're filing a defamation case, you better be damn sure what you got is real, because if the jury votes against you, you're looking at attorney fees, treble damages, and punitive damages for your conduct, which is a lot.
Right. And she seems pretty confident, but I feel like Baldoni's side is also equally as confident. Do you think she has a strong case of getting this dismissed?
Well, here's my first question for you. I'm not following the docket of this case. How is she trying to dismiss it based on 47.1? Based on my communication with Ms. Burke, who wrote 47.1, this is something that's presented to the jury. Now, a defendant or whoever it is can go and file a motion for summary judgment. We talked about that earlier, the MSJ. But if you look at now you can say, hey, Your Honor, based on 47.1, they have no case, dismiss this. I don't think that's really what 47.1 is intended. And here's the problem. Again, got to go back to the language of the statute. I know it's kind of boring, but hear me out. Subsection A, a communication made without malice. What is malice? You have to prove that the person is bringing a fraudulent claim with malice, with intent to harm.
Right.
That's a finding of fact, which almost always goes to the jury. So presenting it to the judge is a toughie, because judges don't like to encroach upon the jurisdiction of the jury. So if they're filing their MSJ, motion for summary judgment, based on 47.1, they need to prove to the judge without any doubt whatsoever that the defamatory accusations are made with malice, are made without malice. So to make that proving to a judge and overriding the jurisdiction of a jury is a very high bar. I'm not saying it can't be done, But if this is as messy as it sounds like it is, there's probably countervailing facts going both ways. And a
Right.
judge is going to say, I can't, it's not my job to choose who's telling the truth. That's the jury's job. And the
Right.
judge is probably going to say, can't make that ruling.
Okay, that makes a lot more sense because she's trying to lean on the fact that she has the fair reporting privilege, the litigation privilege, and the sexual harassment privileges that are all on her side. Um, and claiming that this is why that she was allowed to. So the lawsuit stems from this New York Times article that was published at the end of last year, end of December, so just a couple months ago. She filed a CRD complaint here in California, which I want to talk to you about in just a second because I want to understand how CRD complaints work because that also doesn't make sense. And so Baldoni is saying that her filing this CRD complaint was likely to get some of these privileges, like the litigation privilege, and then to give that to the New York Times. And together they colluded and defamed him by putting out this hit piece against him. The New York Times is currently fighting to get dismissed from this case as well. But with Blake specifically, it all stemmed from this CRD complaint that she filed a couple days before this article was published. But it also shows that she was working with the New York Times and there was communication that was happening as early as October of last year.
Very, very interesting. Look, the litigation privilege, which is very important, I use it. I just had in my office, we had a rather bad sexual harassment case, and I was representing the two young men who were actually sexually harassed in the case. And we reduced to writing a lot of stuff, accusations against the other side, which were, aggressive stuff. Um, because my clients were the victims and they were putting that information out there as part of a lawsuit, the litigation privilege applies to them. Now, does that litigation privilege extend to other parties? Questionable. I would say, generally speaking, no. However, another party can say that these are allegations in a lawsuit. So, for example, if the New York Times is reporting on something, they have to be careful not to say it's true. It's merely an allegation drafted by a lawyer in a pleading, not actual truth. Actual truth, again, is determined by the jury.
Right.
So long as the New York Times is saying these things were allegations, I would wonder how far a defamation lawsuit against them can go, unless, again, we start to get in the world of proving malice. Can it be shown that the New York Times knew or should have known, based on the information available to them, that this was fraudulent to begin with? Because
So
then it could start to get a little complicated for them. However, for Miss Lively herself, she has litigation privilege because she's the one bringing the claim.
So the interesting thing is they're claiming that they have the right to report on legal documents, and this was a legal filing. And we'll get into the CRD complaint in a sec. But so they also claim that they were able to verify the information that was provided in the CRD complaint because there were thousands of documents. It's a quote from them, thousands of documents that were provided and reviewed by the New York Times team that was able to substantiate the claims that were being made against Justin Baldoni. Now, my understanding is those thousands of documents technically wouldn't fall under their press privileges because that wasn't included in the actual court filing of the CRD complaint.
Interesting. Hard for me to say how this is going to break down, but it certainly sounds like a chewy area of the law. I would generally say that if you're out there reporting on a lawsuit, you're generally protected,
Yeah.
especially if they're saying they've done due diligence, so on and so forth. Yeah, it's probably going to be kind of hard to come after the New York Times.
So
Doesn't mean you can't do it.
right. Well, I mean, if any of them, the New York Times is most likely to get dismissed from this, but I think they'll still be dragged all the way through it because I just think there's a lot more in discovery that's going to be coming up over the summer. But so the CRD complaint that was filed here in California, but Blake Lively lives in New York, and the film was produced on the East Coast. It was shot in New Jersey and New York. So any of this alleged harassment took place in Jersey and New York. So there were a lot of questions as to why she would file a CRD complaint in California, if not just to be able to utilize those three privileges: fair use, litigation, and harassment.
Well, look, I don't know New York law, but I would imagine they have similar protections there. So I don't see why you would necessitate her under those conditions to have to file a lawsuit in California just to get protections like that. I'm pretty sure that, defamation, issues of malice and lack thereof are part of New York's jurisprudence. So, why would she then go and file something in California? Well, we have what's called the Fair Employment and Housing Act. And again, I don't know if New York has that. But the Fair Employment and Housing Act is a law that was passed, I don't know how long ago, but it's kind of the Me Too law. It's used, for example, by my office in the sexual harassment complaints that I deal with. And it goes after employers. And by the way, it also has a fee shifting statute, which means if I can prove that my clients were sexually harassed to a jury, I can then ask the judge to pay me my fees for that whole case. And sometimes the attorney's fees are more than the compensatory damages to the plaintiff
Right.
themselves. So it is a statute in California that has teeth, and it seems like that seems to be the constant here. If she, and by the way, CRD, it's an interesting thing. It's a Civil Rights Department. Used to be the Department of Fair Employment and Housing, DFEH, and the DFEH was responsible for the Fair Employment and Housing Act, FEHA. So now we have the Department of Civil Rights is now the one that's responsible for FEHA. So if she's filing under the California Department of Civil Rights, she's requesting what's called a right to sue letter. Now, I don't know if she's filed a lawsuit yet, but typically what happens is you go to the DFEH, or I guess now it's the CRD. You go to that particular department. You say, "Hey, please investigate this," or if you're not going to investigate this, give me a right to sue letter so I can have my lawyer file a lawsuit and do our own investigations. In my office, I never ask the department to do the investigations because it's California bureaucracy, Zach. I'll let you guess how efficient they are at getting an investigation done. I have a feeling, these departments are politically motivated. So if there's a political opportunity in one of these investigations, all of a sudden you might see more aggressive investigations. Maybe that's the case here because there's celebrities involved. Maybe it's not. I would personally hope that because celebrities are involved, that it has no incentivization to our local government. These types of things are supposed to protect average everyday citizens who can't afford lawyers. So I don't know. Do you know if she's actually filed a lawsuit under FEHA or if she's only asked for the right to sue letter?
She asked for the right to sue letter. I believe she got the right to sue letter, but she filed her lawsuit in New York.
Well, I mean, the right to sue letter only applies to a lawsuit in California, so that means
Right, which doesn't make any sense as to what the CRD complaint or the filing in California was for if the lawsuit she was just going to file in New York regardless.
Well, you have. When did she file this? When did she file get the right to sue letter? I guess that's the first question.
That was, I believe it was December 20th.
Of last year?
Mm-hmm.
Oh, she has a year to file a complaint.
Okay, so she still has an opportunity to file a lawsuit here in California.
Yes, the statute in California, which is recently changed by another friend of mine who drafted this particular statute. It used to be that you had 1 year from the date of the last bad act to get the right to sue letter, and then you had another year after you got the right to sue letter to file a lawsuit. Thanks to Tony Jaramillo, she was working at Sacramento to pass a new law which changed the statute of limitations. You now have 3 years after the last bad act to get the right to sue letter, and then you still have 1 year after getting the right to sue letter to file your actual lawsuit. So the timetables, especially for sexual harassment in the workplace in California, are quite extended. I guess we'd have to wait to see if or if not they actually follow through with filing that complaint. Now, if they don't follow through with filing that complaint, it could be just they changed their mind. Strategically, they had a change of heart. Or maybe the right to sue letter was gotten for strategic purposes and had nothing to do with the merits. But, I wouldn't be able to comment on that.
Would it make sense, though, for her to fight this in California if she lives in New York and all of the allegations took place in Jersey and New York?
It could. Was anything. So the question then becomes, how much of this dispute touches California? And I think one of the companies is here. Is that how it works?
Wayfair and I believe it ends with us, LLC, are both filed here. And Justin Baldoni lives here in
But
California.
the actual harassment occurred in New York.
Yeah.
Look, if you have all the money in the world, file them both and see what happens, right? I mean, you may as well see how the cookie crumbles. I think the strongest argument would be file the suit where the bad act occurred. However, the problem with things like that, and courts are aware of this, let's say the problem with this situation is we're talking about rich actors, or at least I assume they're rich. Um, a court might see a situation where someone who is not wealthy, let's just do a hypo. Someone, average citizen, goes to Vegas, gets sexually assaulted on a workplace or something like that in Vegas, and they live in California. They come back to California and they're saying, hey, I want to bring this case. Well, the person, the person who harassed them in Vegas has a company here in California, but the harassment happened in Vegas. For the average person, it's complicated enough getting a lawyer in California to file a lawsuit here rather than having to find a lawyer in Vegas and having them do it there. So the court might say, look, because ultimately you're domiciled here and the company under whose supervision the bad act occurred is also does business in California, then there is enough touching the state of California that would allow us to bring the case here. Now, you're talking about an unsophisticated person, and by unsophisticated, average person bringing that lawsuit.
Yeah.
When you have someone who is, sophisticated by the fact that she has money, status, celebrity, a judge may be less forgiving and say, why are you clogging up California courts with this when New York gives you all the available venues you want and have? So unfortunately, my ultimate answer is it depends, as lawyers often say. And I think it will come down to what the judges think. But to be fair, she hasn't filed anything in California yet, from what you're telling me, other than getting the right to sue letter. So it is possible that may never come to fruition.
Now, the newest thing that's come out, so she filed her motion to dismiss. He filed responses to the allegations that are made. So he didn't file his own motion to dismiss. He didn't amend his complaint. He just filed responses to everything. And in one of his responses, we're seeing that it's revealed that he and Blake, that he runs Wayfair and It Ends With Us LLC. It Ends With Us Movie LLC. But her company, Blakel Inc., which all those companies, I believe, are California companies, just as a side note. But so it looks like the contract between them is between Blakel Inc. and Wayfair. So I understand why she's suing Wayfair and why she's suing It Ends With Us LLC. But would she then also have some sort of responsibility to protect, I guess, herself if her company was technically the one that was involved? Like, she wasn't personally hired by Wayfair to be an actress or a producer in this film. She was technically working under Blakel Inc. So, and I know that that's pretty standard. A lot of, notable people have LLCs and it's kind of their own sort of protection. It's kind of how some people may use that and cheat on their income or their taxes or whatever. People can use that as a loophole. Does she still have a case under harassment if she technically wasn't employed by his companies or by him directly?
Good question. So let me just see if I understand the framework here, because I don't know all the details of the actual case. I know the law, but I don't know all the details of the case. So she was employed by a California LLC, and it was under her employment with that LLC that she suffered the alleged harassment. Is that correct?
Correct. An incorporation, not an LLC.
Okay, incorporation. And so she's accusing a third party of having done the harassment. If that's the case, I don't see why it matters. At least under California law, I don't see what it matters. And I can point this out to you. FIHA, for example, goes so far as to provide protections, not just for employees, but also for independent contractors. Now, what are those protections? Protection A is whether you're an employee or independent contractor, you are protected from harassment. FIHA will protect you from harassment. What may be more interesting is FIHA also requires the employer to protect employees and contractors against against harassment. So FIHA has expectations of how employees act. It has expectations of how employers act, and it has expectations of how contractors are treated. So it's fairly broad. Under the context you've presented, no, I mean, even though she was employed by her own, by her own company, it doesn't, at the end of the day, mean she doesn't have a case against another company. She would have to argue for the purposes of FEHA that she was employed by this other company. Now, what does employment mean? Employment doesn't mean that, well, it can get pretty broad. It depends on what state you're in. And in the state of California, we have the dynamics case. And the dynamics case presents the ABC test. And the ABC test makes it pretty hard for you not to be someone's employee. So let's say you have a company and the company does making films, let's say. Well, if the services you're providing are an integral part of making films, you're probably employed by that company for the purposes of FEHA. Now, the guy who delivers food from Grubhub to the film set, is he an integral part of that film? No. The person who is the in-house catering, who works for the specific shoot, for the specific film, and they're responsible for creating catering on set, are they an employee of that particular studio? Yeah, probably. So you have to understand, being an employee for the purposes of FEHA does not necessarily mean traditionally employed. You may be even getting paid by a third party. Now, all of this comes down to degrees. I'm giving you generalizations. I'm not making conclusions. One side will argue, I am an employee, I'm not an employee. Another side will argue, you are an employee or you're not an employee, depending what is in their strategic best interest.
Right.
And then that will get ruled on by a judge and jury.
Now, even with, her case specifically, there have been a number of inconsistencies in her stories that she's outlined. She's amended her complaints and kind of changed some of those stories. We've seen that the timeline doesn't necessarily add up because she's made allegations claiming, she felt harassed in certain instances. His legal team put together an entire website that broke down the timeline and showed a number of different correspondence, text messages, emails. Here, let me actually pull that up on screen.
These lawyers are having fun, huh?
Oh, they're having a lot of fun.
Yeah.
Look, I'll show you the actual website that they put together. That's publicly accessible for people. So it's called lawsuitinfo.com.
Wow.
And they put a full timeline of events with email correspondence, text messages between Lively and Justin, emails, text messages with crew members. And so they go through a full outline. They have handwritten notes from the intimacy coordinator. They really come at it hard. And so number of inconsistencies. I think this is a really good example here. So in her complaint, she mentioned that she was shown pornographic images from one of the producers, a nude image of the producer's wife that she described as pornographic, which has now been revealed to be this video, which was in relation to a birthing scene that she was going to be performing on set. And this was a still shot of a home birth. So you can see that, the woman, yes, even though she's technically not clothed, she had just given birth. She's holding her newborn baby, and you don't actually see any private parts. But so she described this in her complaint as pornographic. There was footage that was revealed, raw footage and audio, which she was unaware was being recorded. This is just the whole. They have production schedules. And so they reveal all of these text messages to show when allegations were made. And then they show correspondence between Blake Lively, doting on Justin Baldoni, offering to fly him home on her private jet, requesting to work with him one-on-one privately in the editor's room. So a number of those timeline issues kind of contradict the, feelings of being harassed, but yet she's continuing to put herself in situations where she would be alone with him, which to me doesn't really add up. We have the pornography comment. There was footage where she claims that he smelled her and told her that she smelled good, and she felt that that was inappropriate. And then he released the raw audio and raw footage in 3 different takes from that scene specifically, where she says, they're dancing and it's a dancing montage. He leans in and she says, oh, sorry if my spray tan smells. And he's like, it's okay, it smells good. And then she's like, oh, you're probably smelling my body makeup. So again, that context changes him just smelling her and telling her she smells so good. So there have been a number of inconsistencies in her story. that have now been refuted with footage, audio, photos, text messages, email correspondence. Sony has kind of entered the chat as well because they were the distributor and were one of the main financiers of the film. They claimed that she never made any formal HR complaints to them. Wayfair said they never received any formal HR complaints from her directly. Production wrapped in February, and this didn't come forth until December is when she decided to file the CRD complaint. So almost a year after production had even wrapped. What do you think she even has, a chance at one, winning this motion to dismiss, or two, winning her lawsuit altogether? I mean, this is all playing out very publicly, and it's not looking very good for her.
Question, and I don't know if you know this. Do you know if the complaint was verified?
No.
Okay, let me explain what this means because I think this is actually kind of interesting. Most people probably don't know this. A lawsuit is filed and signed by an attorney. My clients do not sign the lawsuit because I file unverified lawsuits, which is typically what is done. Once the loss, and again, this is kind of why you have an attorney. The attorney speaks on your behalf, but doesn't necessarily speak for you. You can only speak for yourself. So you say, well, Daniel, if the lawyer's doing all the talking, what's the point of there even being a client? Well, once you enter, remember earlier we said you file a lawsuit and you go into the discovery phase. Once you enter the discovery phase, they're going to ask me questions, or really they're going to ask my clients questions, and I obviously draft the responses. Despite the fact that the lawyer drafts the responses to discovery, the discovery doesn't count until it's been verified. So if they send me requests for documents and requests for information and I respond, I say, here are the documents, here's the information. It must also come with a document signed by the client saying, I verify the information the lawyer has provided is true. Then and only then can the other side use the verification to impeach the client based on the information provided by the attorney. Brings us back to the original point. Was the complaint verified? In California, you can file a verified complaint. The verified complaint is signed by the client and can be used to impeach the client. So in this case, if the original complaint, the first amended complaint, the second amended complaint, the third amended complaint, whatever it might be, if they were verified, she's in real trouble because now she's self-impeached. If they are not verified, you can still ask her questions about it. But at the end of the day, she can go, I don't know, my lawyer wrote that, because it's not her verification on those documents. Does that make sense? To answer your other question in terms of can she prevail? Again, you bear in mind, guys, I only know California law. I don't know what's going on in New York. But under 47.1, it seems to me it would be very tough to prevail. I spoke with a woman who wrote the law and she's like, this is something that juries are supposed to decide on. Again, literally the word of the statute is it has to be, without malice, which is something that a jury decides, not a judge. Is it possible a judge can decide that at a certain point? If the evidence is so unbelievably overwhelming that the judge can determine that no reasonable jury would vote in favor, then yes, the judge can at that point dismiss. Now that can be appealed, and judges don't like to be struck down on appeal. So I'll let you imagine how likely a judge is to grant an MSJ, assuming that's what they filed in New York, and assuming New York's procedural requirements for MSJ are similar to those here in California, which I'm sure they are. So I would say prevailing on a motion to dismiss, super iffy, is my lawyer opinion.
So I have the actual CRD complaint here. I would assume that the signature would be at the bottom if it were verified, right?
Yes, there should be a secondary document saying, I so-and-so, verify this complaint. The information known to me is to be true, yada, 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 that kind of stuff. This is one hell of a complaint.
Yeah, it's very long.
Can I see this part right here? Let me just, okay, so this is straight up. Okay, this is straight up. So this is filed where? Can we scroll up again?
This is filed in California.
Okay, can we scroll down just a little bit? So sexual harassment under 12940. 12940 is FIHA that we were talking about earlier. And so sexual harassment, retaliation, failure to investigate or prevent, retaliation 1102.5. Interesting. 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 Okay. This is a very FEHA heavy lawsuit. So I need to take back what I said earlier. If this has been filed, she hasn't just gotten the right to sue. She's proceeded to file the lawsuit. Is this?
This looks like.
No, this just
Oh,
looks like
just yeah. These are exhibits.
yeah. Okay. So let me take back what she said earlier. She has filed a lawsuit in California. And when was this filed?
This was filed December 20th, I believe.
Okay. If so, some of the things you were asking about earlier, there should be a section called jurisdiction. It should be one of the first paragraphs that come up. That would show you their argument as to why it's proper to bring this case in California.
Say that again.
If you scroll down just a little bit, there should be like first or second or third page introduction. Let's go past that. There should be a page that says jurisdiction or a subheading that says jurisdiction. It's also possible they mix the jurisdictional arguments into what's that? Factual background.
Well, okay. So we just finished the intro. Now we're into factual background, and then that's what all of these.
It's possible they mix jurisdiction into the facts or introduction, which is perfectly fine. Me personally, when I draft one of these, I have a subheading that says jurisdiction, just to get that out there. So I don't know. You'd have to deep dive into the complaint and see what they say. But look, I can tell you what all these things are. 12940. That's Fair Employment and Housing Act, which was previously oversaw by the Department of Fair Employment and Housing, which is now the CRD, California Civil Rights Department. Those are protections put in place for employees and independent contractors to prevent harassment in the workplace. And like I said earlier, come with a fee shifting statute, which would enable her to get attorney fees, which, by the way, just looking at what's going on here, the attorney fees, I have a feeling, will be astronomical. Yeah.
I mean, and their trial's not even set for another year. So we still have a whole year of back and forth. I mean, next is going to be discovery, and there are predictions that all of their famous friends that seem to now have their fingerprints all over this film, Gigi Hadid, Taylor Swift, Hugh Jackman, Bradley Cooper, are all expected to be deposed over the summer ahead of completing the first step of discovery. So as soon as all these motions to dismiss end up getting in, my prediction is that they will all be dismissed and we'll move forward into discovery. But that's where we're at right now.
Let me ask you, this is California, I might know a little better. When you say motion to dismiss, are we talking about a demur or a motion for summary judgment? Do you know?
I think it's a motion for summary judgment.
Okay, MSJ. Good luck. We'll see.
Oof. They're estimating about 15 million in attorney's fees.
All right. Probably more realistically 4 or 5, but you anchor high in these types of cases.
Well, I guess, but I mean, if it's Brian Friedman, he's representing, multiple. How many parties are here right now? Wayfair, Justin Baldoni, Jamie Heath, Steve Sorowitz, Melissa Nathan, the agency group PR LLC, Jennifer Abel, RWA Communications LLC, Jed Wallace and Street Relations are separate. That's a separate lawsuit. Okay,
well, maybe there is more in terms of fees than I thought there would be. And by the way this works, guys, it's not just one lawyer's fee. You got the partner, you got the secondary partner, you got the associates, and if they have a feeling it's going to go in a certain way, they will rearrange the billing to maximize it.
Oh yeah, and then there's a separate case. The lawsuit with the New York Times is separate. Justin Baldoni and the Wayfair parties are also suing the New York Times independently.
Yeah, like I said earlier, if there's one person who I just based on, again, I don't know all the facts here. I don't know New York law and jurisdiction, but generally speaking, freedom of the press is a big one. And I mean, it's literally constitutional law. It supersedes any state. It's federal law. So with something like that, they're going to have a lot of. Now, look, you can bring someone into a case knowing that you're not going to prevail against them. In fact, that's why Vicky Burke wrote 47.1. A quick sidestep here. I think this might be interesting. There's a cottage industry that has come up with law firms that basically chill people's freedom of speech because they will sue them for defamation, not because they're going to win on the defamatory claim, but because they want to crush them in attorney fees. Let me just give you a quick example. Bill Cosby. Bill Cosby was threatening to sue victims. I will sue you for defamation, I think is something he or his representative said. So the whole point of 47.1 is to allow on the back end something to balance all of this out. So it is just an interesting thing because there's questions of balancing factors. We want victims to come forward. We also don't want to make it so loosey-goosey that people make stuff up and have no punishment for it. And interestingly enough, the spat between some actors and actresses seems to be bringing all these questions up to the surface.
Yeah. Johnny has a question. Zach, could you ask about the CRD being issued the same day it was received with no investigation first? That's really interesting. So she filed the CRD complaint and then within the same day had her right to sue letter.
Mhm. That's how it works.
Is that standard?
Yes.
Oh, it can happen that quick?
I don't ask for a CRD investigation. I just ask for a right to sue. I don't need the government doing my investigation. I'll do a better job with respect to the government. Takes the city of Los Angeles 10 years to fix like a pothole, guys. I'm not. So you get the lawyers involved, and the private sector moves more efficiently. Completely normal. As soon as I get the right to sue letter, I go forward with it.
Got it. La Madame Claus says, does the CRD still play a role in the trial?
So
Well, I would imagine, right? Because the defamation is related to the allegations that are made in the CRD complaint.
sure, yeah, absolutely. I think so. One thing, just to be clear about the CRD, that's just like a department that issues the right to sue. In reality, the claims that are going to play a role are the ones that we saw in the lawsuit that you had up earlier: sexual harassment, retaliation, failure to prevent sexual harassment, et cetera, et cetera. So this is the Department of Civil Rights is doing is saying, hey, you can go forward with your lawsuit. The claims are all made under FEHA.
With Blake Lively filing the CRD and then immediately requesting the right to sue letter, thus removing it from the formal process, how does it affect the New York Times' claim of fair reporting privilege?
I don't see why it would. It really, the whole thing about her getting a right to sue letter is, how to put it, like the lawyers have their assistants do these things. It doesn't
Yeah.
really have much influence on anything.
Who do you think is winning? Do you think that she has any chance of getting dismissed?
Guys, I'll be honest with you. I don't. I follow Zack and I follow what he posts, and I think this is really interesting. But in terms of who the ultimate victor will be, I have no idea.
Samantha says, my question, does 47.1 apply to independent contractors? FEHA is something different. ChatGPT says 47.1 does not apply to contractors, but only to employees.
It's a good question. One thing I'll point out: don't trust ChatGPT. It's not reliable. I actually did use ChatGPT earlier when I was researching this stuff, and I read the actual law, and it had nothing. ChatGPT was not right. So that's a good question. If you give me a sec, let me pull up 47.1 and I can take a look.
Okay.
But you can ask me something else in the meanwhile while I pull this up.
Brigitte wants to know about criminal extortion charges. Is there a more formal question, Brigitte, about criminal extortion charges? I believe that's one of the allegations that Baldoni's made against the Lively parties, is that they tried to extort them. The Lively parties have argued that there wasn't any extortion because there was no exchange of any money, but arguably them trying to hijack the film and get the rights to the sequel could be a form of extortion.
Yeah, and I don't do criminal law, so unfortunately that's outside my barometer. But I'm looking here at 47.1. By the way, whenever you look up law, try to find it from the California legislature because other websites get it wrong. I'm not seeing the word employee anywhere in here. I'm seeing workplace, the word workplace, but I'm not seeing the word employee. So I would imagine independent contractors can assert this as well. So and I'm not sure. Yeah, I think And an act of workplace harassment or discrimination. Workplace harassment or discrimination can be done towards an independent contractor or an employee. So I think 47.1 applies to both.
Kaylee says, can we talk about the fictitious subpoena used to collect the text messages? So this is interesting. So this was spearheaded by a former publicist that is now being sued. But so she basically took a number of text messages between Baldoni's team while she was working for Baldoni, and took those text messages and correspondence and gave them to Blake Lively. And those were the text messages that Blake Lively is now using to argue that there was an alleged smear campaign or retaliation campaign against her. So
Interesting.
the question, though, becomes if Blake Lively obtained these text messages, a subpoena, if they're claiming that she obtained them, she's claiming that she got these via subpoena, or at least that's what the New York Times reported, was that Blake Lively obtained these text messages via a subpoena, but yet there was no active litigation, there was no active lawsuit, there was no reason a subpoena would come into effect here.
Yeah, you need a civil lawsuit or to be part of the government to issue a subpoena.
Yeah, so presumably the subpoena part is not true. She just used, the subpoena was just used to say that this is how they obtained the documents, probably assuming nobody would dig into that further. The case has blown up, and now it's like, well, it doesn't make sense why there would be a subpoena to obtain these messages to begin with.
This is wild.
Blake didn't file her lawsuit until Justin filed his lawsuit against the New York Times first. She got her right to sue in California, but didn't actually file her lawsuit in California. Yeah, my understanding is she filed a federal case out in New York. But what if she's lying? Well, that'll be determined by a jury should it go that far. I have several legal experts say Lively will have to pay $100 million in damages. Does that estimate sound close to your guess? Johnny, so Baldoni's suing for $400 million. And obviously, when you throw out your initial number, it's kind of like a negotiation. You know you're going to fall somewhere below that. So I doubt he's going to win $400 million in his lawsuit. But I mean, if you're suing for 400, I think, and if you win in the end, I think 100 mil is probably fair to assume, right? To guess.
It really depends on what the facts and circumstances are. Like he'd have to show so he's filing. So he filed against her for defamation as well. So it's just cross defamation lawsuits. Is that what this is?
No, she's suing him for harassment, and he's suing her for defamation.
I see. Well, he'd have to show that the defamatory acts caused him economic harms. And you can also show emotional distress and stuff like that. But look, if you want to show an economic harm, and my clients come to me all the time, and they say, "Hey, Daniel, but for I do a lot of personal injury, but for the car accident, but for getting the burns that I got, but for God forbid amputations, I would have had these opportunities available to me." And I say to my clients, I'm really sorry that you had this injury. I'm really sorry that you broke your arm in half and now you can't use your arm. But can you show me that there was a contract there that you lost out on? Now, someone like Baldoni, he probably can show a few contracts.
Well, actually, this is where it's really bad for Blake Lively. So Justin Baldoni was previously represented by WME. And Blake Lively and Ryan Reynolds are represented by WME. Big talent agency. Lots of celebs are repped by like CAA, WME. So the CEO of WME went on the Freakonomics podcast, or went and did a live podcast for Freakonomics on stage in front of an audience. And in this interview said, I knew I was going to be asked about this, and said, I fired Justin Baldoni, Justin Baloney, said, I'm ride or die for Blake and Ryan. I've known them for over 10 years. They're good people. We fired Justin Baldoni. And he was dropped right after this New York Times article came out. He was dropped by WME. Not only that, but then Baldoni's team claims that right before Justin Baldoni was dropped by WME, Ryan Reynolds accused Justin Baldoni of being a predator to one of their agents or partners. We don't know who at WME Ryan Reynolds spoke to, but he called him a predator. And so Ryan Reynolds has not denied calling him a predator. Ryan Reynolds' argument in his motion to dismiss was that he has no power over WME, and technically calling Justin Baldoni is, one, his opinion, and two, he believes that Justin Baldoni is a predator, so that's not defamatory, and that didn't lead to him being released by WME.
Interesting. I feel like all of Hollywood is sweating right now because this sounds like you might have to throw subpoenas WME's way, right? Just to figure out.
I'm sure WME is definitely going to get part of this. But the interesting thing is WME dropped Justin Baldoni after this New York Times article came out, right? Unsubstantiated claims, just allegations. However, WME, to my understanding, still represents Diddy. So they can't say that they dropped Justin Baldoni because of these allegations against him when they still represent Diddy, as far as I'm aware.
Look, it sounds pretty causal. The guy came out and said we dropped him, right? Like they said.
He said we fired him, and he said he's ride or die for Blake and Ryan.
Look, Ryan hit 1 billion on that last Wolverine Deadpool movie, so probably the client to keep, right? But it seems like there's damages there. If those are my damages, I'd like it.
MJ says, thought that Blake was technically working for the LLC does not mean that she cannot directly sue Wayfair and Justin, and should be using the LLC. Can't have it both ways. LLC saves you on taxes. Yeah.
Okay. Here's the problem with this. Let's say you're working for my film set or whatever it is, and you're working as an independent contractor through your own LLC. Okay. Does that mean I just get to abuse you the whole time? Of course not. The protection is still going to apply, and harassment and failure to prevent harassment apply to employees and independent contractors. And again, to be an employee for the purposes of bringing this lawsuit is different than being an employee for the purposes of who's sending you a paycheck. So long as you can show that what you were doing was integral to the company's business who you were working on behalf of, and so long as you can show that they had some control over the workplace, which I'm sure you can, you're going to be an employee for the purposes of FIHA.
Yeah. I think we clearly debunked the independent contractor versus employee thing. Disney's going to be brought into this. They have, so the interesting thing about the Freakonomics podcast with Ari Emanuel, so it was a live podcast, so it happened on stage. And so obviously they record those and then air them on the podcast later. And when the podcast was supposed to be aired, Freakonomics came out and said, we had this very rare technical glitch and we no longer have the audio or video of that podcast. So we're not going to be releasing it after all. But somebody in the audience recorded it on their iPhone and ended up leaking it online. So you very clearly hear Ari Emanuel, the CEO of WME.
This should be a law school hypothetical. This should be an exam. Law school.
But I mean, just based off of all the information, I know you haven't covered it closely, but just based off of all the information that I've given you so far, isn't it wild that they're still trying to fight this? Considering I feel like there's so much evidence against them. The claims have been completely unsubstantiated. The damages are clear. He lost his agent, which I'm assuming would also come with whatever pending contracts were on the table. The film has been tanked. He had the rights to a sequel, so he can't move forward with the sequel because the image is completely tarnished.
There's a there.
It's crazy. Do you think any new laws may need to be written to reflect lessons learned from this case?
Not off the top of my head. FIHA has great protection. You have anti-slap. You also have now 47.1, which again was written by a friend of mine. I'm personally comfortable with the California statutory scheme, and it's favorable towards employees. I gotta say, California wants to prevent. Look, a statutory scheme is going to lean based on the politics of the state. California leans left. It's going to have more protections in for employees. Go to a place like Texas, it leans right, or at least it used to. It's going to have more protections in place for employers. This is why every corporation incorporates in Delaware. Delaware protects the corporations. So in a state like California, we already have a lot of tools. And it's not just 47. There's Civil Code 42. I don't remember them all off the top of my head, but there's all sorts of stuff out there that really protects people. I don't know if there's a need for more laws.
MP says, what about a petition to perpetuate testimony and preserve evidence in California? A pro-Blake lawyer said that could act as some kind of subpoena for the publicist that gave Blake the text messages.
Well, okay. I think this is bringing up something that's called spoliation of evidence. In all my lawsuits, before I file my lawsuit, and when usually I'm stealth in the beginning. The first 6 months of a lawsuit, no one knows I exist. I'm behind the scenes before anyone knows I exist, gathering evidence. At a certain point, I go loud. Now, that means I start sending out correspondences or I start just filing the lawsuit. Can go either way. Sometimes you start sooner, sometimes you start later. Now, there are certain circumstances where you might not be filing a lawsuit for a while, but you want to prevent people from spoiling evidence. That's when you send a spoliation letter and you say, hey, you have a litigation hold. Do not delete anything related to this lawsuit up until it's over. If they delete stuff and you can show they deleted stuff after they received your spoliation letter, then the judge can instruct the jury and tell the jury you can presume anything that was deleted after the spoliation letter was received was unfavorable to the party who deleted it. Now, at the end of the day, that jury instruction can be pretty damning, but you don't know what was in the actual information that was deleted. So someone might say, look, it's better the judge instructs them to assume the information is bad rather than actually seeing the bad information. So go ahead, ignore the litigation hold, and spoil the evidence. Not ethical, but it can be done.
Yeah. Well, I mean, now Justin Baldoni is actually suing that publicist for providing those communications to Blake Lively. Because, I mean, I would understand there are some protections he would have, right? Because he was a client of this publicist. And so you would think that he would have some sort of right to privacy
Oh,
and
is that
not.
how the publicist got it?
So what happened was the publicist, her name is Stephanie Jones, has a PR firm, and so under Stephanie Jones, there was a publicist named Jennifer Abel, who's currently with Baldoni, being sued by Blake Lively or actively litigating against Blake Lively. Jennifer Abel left the company and took Justin Baldoni and Wayfair as her clients with her. So Stephanie Jones, who owned the company, confiscated her phone, and then from Jennifer Abel's work phone, pulled those text messages and gave them to Blake Lively.
Oh, that sounds real iffy. What do you mean confiscated the phone?
It was a company phone. So she said, if you no longer work for me, that's my phone now. And so she made her turn the phone over. And so technically she owns the phone because it was a company phone, but then she took the correspondence that was on Jennifer Abel's phone and provided that to Blake Lively. She said via a subpoena, but as of right now, a subpoena doesn't make sense.
Yeah, it's hard for me to say in terms of I don't know who would technically have, I don't know, ownership of the cell phones outside of my wheelhouse. But if that was a company phone, yeah, you got to be careful what you're putting on it because the company owns that phone.
Well, Jennifer Abels claimed that this was her personal phone number. So even though the phone was technically owned by the company, I would assume that she's also entitled to some level of privacy, as is Justin Baldoni. I mean, you don't think you're going to hire a publicist that's in turn going to,
Bless you.
in turn going to leak your messages to somebody that's planning to sue you.
This
It's
falls
also
under
convoluted.
this falls under reasonable expectation of privacy, REP.
Yeah.
I really don't know privacy law all that well. Again, I do, wrongful death, personal injury, child abuse. But I'll give you a quick factoid that's interesting about REP. If you are in a restroom and you're using the restroom, you're literally on the toilet, and a police officer comes inside the restroom, do you have a reasonable expectation of privacy? Well, police officer can look because in the restroom that the stalls, but you can, where the stall doors don't close perfectly, you can put your eye and see inside the stall. So police have argued you don't have a reasonable expectation of privacy in a bathroom stall insofar as they can just look through and see you with their eye, put their eye right up at the. So this is messy. This is messy. All of this.
It's very messy. I suggest you read up on it and maybe even cover it on your podcast because a lot of it is there are just so many layers to it, and every week there's another piece that unfolds. I mean, even like Ryan Reynolds claimed, like he's not denying that he told an agent at WME that Justin Baldoni should be fired because he's a predator. And Ryan Reynolds said, well, I believed he was a predator. And so therefore, I didn't defame him. And if they fired him, that's them. That had nothing to do with me. But Ryan Reynolds, who brings in Deadpool money, I would argue has a little more power at WME than he wants us to believe that he does. Let's see. Any more final questions before we wrap? It's not just personal privacy. I think there was a contract protecting the communications in relations to Wayfair with Jones' work, including once their services were terminated. I would think that that's standard, right? If you hire a PR firm, all of your communications you would assume are private.
Yes, I would. And if it was contractually done, then you have a contractual claim to make as well.
Yeah. Mentioned the cherry pick text messages. So that was the other thing, is the way the New York Times presented and the way that Blake Lively's team in the CRD complaint presented the text messages that they obtained from Stephanie Jones. Eliminated context. So there were certain text messages that were published by the New York Times that said, reference like a Daily Mail article, and they say, oh, we did such a good job, presuming that they were saying they did such a good job planting that Daily Mail article. But then you see the full correspondence and you can see that these things were said sarcastically. There were emojis that were edited out of the text messages to make them appear more literal versus sarcastic. So when Baldoni then released his side of the text messages, he's like, wait, this is the full thread. These are all the pieces of the communication that were eliminated to make them appear a certain way and take them out of context, when here's the full context of the messages. So there was a lot of, the collusion does seem like a reasonable argument to make, that the New York Times and Blake Lively conspired together, which is the allegation being made against the Wayfair parties, that they conspired together to defame Justin Baldoni.
Jeez.
It's messy. All right, Daniel, thank you for coming back on the podcast. I always appreciate you coming in and dropping your legal gems. Anything you want to share before we leave?
Yes, just one thing on my mind. Good on you. By the way, guys, I talk to people about the law. Most of them have no idea what's going on. I can actually sit and have a conversation with Zack, and he knows what's going on. And not only that, you're presenting the law to your audience. And it's so nice to see people who don't work in my profession nonetheless having such an interest in the gritty details. So good on you, sir. Good on you for having the interest, and good on you for letting me come here and actually read, statutory law to your audience. I think that's important.
Yes. Oh, to clarify, thank you for saying that. I'm fascinated by this, and learning all of the legalities is very fun for me. Samantha says she's suing for retaliation, not harassment. I believe she is suing for harassment and retaliation, but she's claiming she was harassed, and then Justin Baldoni retaliated against her by launching a smear campaign, a retaliation campaign, and so that's why she's leaning into these privileges in California. All right. Thank you, guys. Anything, do you want to direct them to your YouTube channel, Instagram account?
Sure. Instagram, Daniel Forouzan. My office is Forouzan Law. Easy to find me. Feel free to connect on Instagram. Would be a pleasure to speak with all of you.
And Schmoozin' with Forouzan, is that still going?
I haven't. I'm looking for a studio right now before I relaunch it, because I want to start. I have a few that I want to do in person. I'm so busy. I have a wrongful death trial coming up in June, a child abuse trial coming up in August. So outside of that, it's kind of hard to see anything else right now.
Well, best of luck. You're doing the Lord's work, fighting for all these people that need a real champion to have their back, and not one of these Tom Girardi lawyers.
Yeah. Well, thank you for having me on, Zack. I appreciate it.
Appreciate you. Have a great rest of your day, and you'll have to come back again soon.
I would love to, particularly on this case. Let's see how the discovery motions go. That could
discovery is going to be messy. So the deadline, I think, to get all the depositions in is August 14th. So I would imagine, and from what I'm hearing, they're doing video depositions. So when those get presented in trial, I'm very much looking forward to that.
Me too.
All right. I'll talk to you later. Thank you.
Thank you.
All right, guys. Thanks for tuning in. Go show Daniel Forouzan some love. He is on Instagram. You can check out interviews from his podcast. It was called Schmoozin' with Forouzan. I'm going to convince him to bring it back and to break down more of these celebrity legal scandals on that YouTube channel, because it's actually really good. Yes, depositions are coming. All right. Thank you, guys. I appreciate you. Have a great rest of your day. Just a reminder, I am donating 50% of all merch sales between now and April 11th to the No More Foundation, which is the foundation Justin Baldoni wanted to support to help victims of DV, to bring awareness. So as Glamour Magazine and Stephanie McNeil wanted to call us a bunch of mommy sleuths, you can get a daddy sleuth, mommy sleuth, Justice for Justin T, and all of our classic merch is also on sale right now too. I'm donating 50% of all proceeds now until April 11th. So get your orders in. When your orders come, please take a photo, post it, tag me. I'll talk to you guys tomorrow. Yeah, what's today? Wednesday. I thought today was Friday, but we have a lot more tea to cover. So stay tuned, get ready, get your merch at nofiltermerch.com. Let's raise some money for the No More Foundation. All right, guys, I will talk to you later. Give me a follow, Just Plain Zack. Follow the podcast at No Filter with Zack. And I will be back here tomorrow, same time, live on YouTube. All right, bye, guys.